It's agreed.
I move that the bill be read a second time. It's now 3.5 weeks since the tremendous result in the marriage equality referendum. It was even heralded as a social revolution by Minister Varadkar and others. Over 62% of those of whom voted for marriage equality. Now this House has the chance to vote for employment equality to go with it. That referendum result was a powerful blow against discrimination, against inequality and against homophobia. It showed that the traditional picture of a socially conservative majority in Irish society is simply and fundamentally incorrect. It shows that immense social change has taken place, and it now itself becomes a pressure point for more change and progress. Gay rights campaigner Harvey Milk once said that hope will never be silent, and those who mobilised in the recent referendum campaign will not now be silent. The tens of thousands who registered to vote, the tens of thousands who came home to vote, the tens of thousands who campaigned to convince others to vote yes. These people will not now be silent and will continue to campaign. The fact that Ireland was the first country to vote for marriage equality in a popular referendum sends a powerful signal right around the world that marriage equality can be won and that change can happen. But it also sends a signal for further change in this country, because it remains the case that discrimination and homophobia continue in this state. We know that LGBTQ people are 7 times more likely to attempt or commit suicide than straight people. We know that young LGBTQ people face much higher rates of depression and self-harm. We know that according to a recent EU survey, half of LGBTQ people were discriminated against in the past 12 months because they were LGBT. Nearly 1 in 5 were discriminated in the workplace in the previous 12 months, and 8% have been physically attacked or threatened with violence. The vast majority of that discrimination and harassment goes unreported because people believe that nothing would happen about it and change wouldn't happen. So we know that discrimination, inequality and homophobia persist. Legal change cannot change all of that in one fell swoop, but it can send a signal that homophobia is not acceptable as opposed to being enshrined in law. The ban on blood donations from gay and bisexual men continues. It must be ended. We need gender recognition legislation that takes into account all of the criticisms made by transgender people, including those who are under 18. We need it passed into law as soon as possible. And in particular, and this is what this bill from the Anti-Austerity Alliance is about, is ending the incredible situation whereby church-run schools, hospitals or charitable institutions can discriminate against LGBTQ people, atheists, unmarried mothers, divorced people, minority faiths and others. Now is clearly the time to end all of the legal discriminations as a step towards real equality and as a step towards a progressive, secular state with separation of the church and state. The section of the Employment Equality Act, the infamous Section 37, which we are trying to remove here, is particularly offensive. It currently functions as an exemption to the employment equality legislation. It allows a religious, educational or medical institution which is under the direction or control of a body established for religious purposes to discriminate against an employee or prospective employee in order to prevent them from undermining the religious ethos of the institution. This broad exemption covers thousands of workers in this state. It includes teachers, SNAs, nurses, doctors, healthcare assistants, charity workers and others, particularly in a context when close to 95% of our primary schools, 50% of our secondary schools and many of our hospitals are church-run. It's extremely a serious issue. The legal meaning of this section is to permit discrimination against workers in order to maintain the religious ethos of the institution. In practice, it means that LGBTQ teachers can be legally discriminated against. It means that atheist hospital workers can be legally discriminated against. It means that workers in a charitable institution who are, for example, unmarried mothers or have relationships that may be deemed to be against the religious ethos of the Catholic Church can be legally discriminated against. It means they could be fired on those grounds without having legal recourse to the equality legislation. It also means that they could, and in fact are, be discriminated against in terms of promotion opportunities, and above all it creates a chilling effect whereby LGBTQ workers, teachers in particular, are told not to be open about their sexuality. It adds to a socialising of homophobic attitudes and homophobic behaviour and cuts across those who attempt to intervene and stop homophobic bullying, for example. This is not a new issue. It originally arose in the Eileen Flynn case, where Eileen Flynn was sacked in August 1982 because of her relationship with a separated man, which was then upheld by the courts. This section has been opposed by the teachers' unions since it was introduced, and in 2012 the then Minister for Education, Rory Quinn, promised to get rid of it. There has been a bill amending Section 37 stuck in the Seanad for over 2 years, and Minister for Equality, Aidan Reardon, has not made the promised amendments yet and brought it forward. However, this is the first time that this has been brought to second stage in the Dáil. We have had enough of waiting for this, particularly in the context of the referendum result. It is essential that this is gone in time for the new school year starting. I'm happy to say that this bill has the support of a very wide number of groups, including the Gay and Lesbian Equality Network, the ASTI, the INTO, TUI, Atheist Ireland, LGBT Noise and ICTU Youth. To go through our bill very quickly, our bill is very simple. It deletes the exemption that currently exists. Instead, it clearly states that no religious organisation may give less favourable treatment on gender, marital status, family status, sexual orientation, religion, age, traveller community, disability grounds or on the grounds of race to employees or prospective employees in services it operates, including educational or medical institutions. That means that the discrimination against LGBTQ employees and others in schools, in hospitals and elsewhere would no longer be legal. It replaces this subsection with a much more limited wording which would allow a religious organisation itself, rather than a service it operates or directs, to discriminate in favour of an employee on the grounds of religion alone, where it is a justified occupational requirement. This would, for example, allow the Catholic Church to discriminate in favour of Catholics when employing priests. We have heard that the government will not oppose this bill, which is very welcome. We would urge that it does not, after hopefully passing tomorrow night, does not sit on the shelves but is quickly brought into committee and is enacted before the start of the next school term, which means before the summer break. In previous debates in the Seanad, the argument has been made that change such as what we have proposed here would be unconstitutional. We do not believe that to be the case. The Constitution gives every religious denomination the right to manage its own affairs. It also says that the state shall not make any discrimination on the grounds of religious profession, belief or status, and that all citizens shall be held equal before the law. These are conflicting rights contained in the Constitution, and it's up to the Oireachtas to balance between those rights. As things currently stand, the balance is overwhelmingly in the direction of the right of religious denominations to manage their own affairs, even extending to institutions that they run, control or direct. Our bill would shift that balance more in the direction of workers to equality. However, it would continue to recognise the right of religious denominations to manage their own affairs. In any case, if there are particular issues with wording in our bill, that is for committee stage, where they can be dealt with appropriate amendments. I want to deal briefly with some of the other bills that have attempted to address this issue. The bill that the Labour Party and the Government has referred to on a number of occasions, and which is currently at committee stage in the Seanad, was introduced by Senator Ivana Bacik. That bill would eliminate discrimination in publicly funded institutions, except on the grounds of religion, where this is a genuine, legitimate and justified occupational requirement. That bill would represent an important step forward relative to the current situation. However, in our opinion, it's too limited. The Irish Council for Civil Liberties has correctly described that bill as providing a partial thaw in the chilling effect. The two key limitations are, firstly, the fact that it is limited to publicly funded institutions. It would mean that church-run institutions that don't receive state funding could continue to discriminate on all of the grounds. Employment rights should not depend on whether one's employer is in the private or public sector. Secondly, it would retain the grounds of religion, in particular as a means of discrimination, including in institutions run by religious institutions, denominations, as opposed to those religious denominations themselves, where it is demonstrated to be necessary by the employer. That would mean a potential continuation of discrimination in schools, hospitals and charitable institutions. In particular, it would leave atheists open to being discriminated against, but may also still include LGBTQ people and others who may be deemed to be in contravention of a particular set of religious beliefs. Senator Averill Power introduced a bill in 2012, again in the Senate, which would represent a big step forward over the current situation. Again, though, it does not delete the relevant subsection of Section 37, and the existence of a right to discrimination on ethos grounds would have remained, even if it was somewhat restricted. The bill published by Sinn Féin Deputy Jonathan O'Brien in the Dáil in February 2013 has the same issues. To return finally to the more substantial points relating to this bill, we believe that people voted in significant numbers and mobilised for marriage equality, and now we should vote for employment equality. There are those who will say, well, nobody was ever fired for being gay and being a teacher, so what's the big deal? The big deal, which is felt on a daily basis by teachers in particular, but also others, is the chilling effect on employees in schools, hospitals and elsewhere right now. The big deal is the gay teacher who entered a radio competition for a wedding online earlier this year and who had to pixelate her face in the video because she was nervous about being seen to be openly gay. As Minister O'Riordan said at the time, people should be horrified to live in a country where people think they have to pixelate their faces in a competition to protect their jobs. He then, according to the Irish Times, pledged to have the Act changed by Easter. The big deal is for those teachers who spoke out to the Journal news website last year and made clear that they were shunned in school after being found out to be gay, where they were dropped from training the football team, where they were left isolated in the staff room, where they didn't feel able to tackle homophobic bullying by students. It is a very big deal that we have laws in this country which allow discrimination against public sector workers. This bill is part of the movement for progressive social change, which is a demand being heard across the country in the light of the marriage equality referendum. We should clearly not have teachers or health workers or any workers discriminated against because of their sexuality, because of their religion, or because of anything else. More fundamentally, we believe we should not have any church controlling our education or health services. We need a secular society with properly funded and state-provided public services. A secular society means that everybody will be perfectly entitled and free to practice whatever religion they wanted, with no interference by the state, and the state would defend their right to do that. But it means there should be a separation between the actions of the church and the actions of the state, without, as has happened from the foundation of this state, the church being relied upon to run and control vital public services. We believe this bill is a very important step in that direction, removing the right of discrimination against LGBTQ, atheist, minority religions, unmarried mothers and others. Passing it here will be a blow for employment equality to join marriage equality. It must be followed up by quickly being debated at committee stage and being enacted, and I would underline the point that it must be done before another school year starts in September.
Thanks, Deputy Root.